I'm going to go through the entire trademarking process with you guys from start to finish, how you guys, just so you guys understand exactly what's involved and the entire timeline, and what you guys are looking at in terms of the application process and how long things will realistically take to get done. So one of the things that I want to just stress is that a lot of the delays are actually due to the trademark office. So the trademark office has a whole slew of examiners, but they're really busy. And so they can't respond right away. Whenever you respond to an office action, whenever you file a statement of use, they don't deal with it right away. It's not like it comes in their docket and they handle it that day, right? So there's inherent delays in the entire process. So just keep that in mind. Um, but let's go through it. I'm going to talk about both types of trademark applications, but I want to just give you guys a high level overview of what you're getting into when you submit a trademark application. So it all starts with filing. Okay, so you're going to initially file a trademark. Okay, this is the first step of the process. So you're going to start by filing a trademark application with the trademark office. Now, there's two types of general applications: actual use applications and intent to use applications. If you guys are a little unsure about what those are, go back and watch one of our prior episodes. But real quick, I'll just give you guys a quick explanation. So intent to use applications are trademark applications on your brand name or logo, before that you can file before you've actually started branding your products or services with your trademarks. So if you have a cool new brand name that you want for your clothing, but you haven't yet started selling your clothing, then an intent to use application would be the route for you to take. Now, actual use applications are applications on trademarks that you're already using to sell your goods or services. So actual use applications would be more appropriate if you already started selling your clothing, but you want to take steps to protect the brand name. So that would be an actual use application. Now, the one key thing that I want to get across is having a filing date is really, really important. And you want to get as early as filing date as you possibly can. So I encourage you guys to file intent to use applications if you're sure that you guys are going to be wanting to use those brand names or logos in commerce. Now, the one key thing to understand is that both types of applications are going to continue along through the same trademarking process, as you're going to see in this episode. I'm going to show you guys a timeline, and you guys are going to be able to see that they largely track the same flow. So as I said before, there's two types. There's actual use applications and intent to use applications. For actual use applications, you're going to have to include the owner information, the mark, and a specimen. So a specimen is proof that you're actually using the mark in commerce. So in the case of clothing, as I've said, you would submit, for example, labels, for example, the back tag, for example, on the back of a shirt that actually shows the brand name on the shirt. Okay. Now, again, if you haven't yet started selling your clothing, then you would file what's called an intent to use. So that would just have the mark information, as we have here, and you do not have to submit a specimen. All right, so those are the two types of applications. So once you file, what happens? Well, after you file, there's a delay. It takes about 3 months, okay? But in about 3 months, your application is assigned to a trademark examiner, okay? So once it's assigned to an examiner, this is when the examiner is actually going to start reviewing your application, and move the application forward in terms of figuring out whether or not you can possibly register the mark, okay? So again, it takes about 3 months, and it's going to be after you initially file the application. So at the 3-month mark, it's assigned an examiner, and the examiner is going to do a few things. So it's going to, went backwards here. So they're going to do an analysis. They're going to do a likelihood of confusion analysis. And the way they do that is they search, okay? So they do a search on the trademark database to find other similar marks that might be in the same class of goods or services as you, okay? They also search for other formalities, for example, merely descriptive. So if the mark that you're applying for merely describes the goods and services that you're selling, then you're going to get a merely descriptive rejection. Okay, so they do this examination. They see if it is if you would be lawfully entitled to have a registered trademark for your brand. Okay. Now they also, if you filed a Section 1A, they're also going to review the specimen, and if there are any issues with the specimen, then they're going to raise them. And then possibly they might require it that you disclaim certain parts of your mark. So this is just by the way, this is just a quick, brief overview of some of the common issues that we've seen trademark examiners arrays. There's a lot more, but these are the most common, I would say, and probably more than likely the ones that 90% of you are going to be dealing with if you do file a trademark application. Hopefully not, though. Hopefully not. Hopefully you don't have any of these issues and your trademark application just flies right through. So again, you file your trademark application, and then you're looking about 3 months before it's assigned an examiner, okay? So then it's assigned an examiner. They're going to perform an examination of your application, basically reviewing it for formalities and confirming that it is possible to register your mark. Now, after the examination process, assuming that you make it, it's going to get to a publication period, okay? Now, this period lasts from 1 to 6 months, okay? Now, assuming nobody files an opposition, the publication period is going to close after 1 month, okay? So 1 month after the publication period, it'll close, assuming nobody files for an extension, and then you've made it, okay? You've gotten essentially to the end of the process. At this point, after the publication, as I'm going to point out in a second, you're either going to have a registered mark or you're going to have to submit what's called a statement of use. But surviving the publication period is an awesome thing. It's really good. But one thing I want to point out, from the initial filing over here, to the publication period over here, even assuming the publication period lasts for 1 month, you're still looking, I would say conservatively, 6 to 8 months. That's why I'm saying get your trademark applications on file early and as soon as you can. Don't wait around. Try to get your trademark application on file as early as you possibly can. It'll just be a lot better for you, and you won't just be waiting around in limbo. Now, one thing I want to point out: remember that publication period. It is possible for it to be expanded for up to 6 months. So parties that feel like they might be harmed by the mark, let's say there's another brand out there that has a very similar name. If they feel like your mark is a threat, they might file for an extension of time to file what's called an opposition. So again, that publication period can be extended, but assuming it's not extended, it's going to close after 1 month. Okay. So now what happens? Okay. Now, really awesome news. You survived the publication period. Okay. Now you have basically 2 options. Okay. So the first option is that your mark can be registered, or if you filed a 1A, it would just move on to registration. Okay. So you filed a 1A, your mark's going to be registered in the Federal Register. Okay. This is a really good result. This is one of the nice things about going directly under Section 1A, is that right after publication, your mark is registered in the Federal Register. Okay. Now, let's say you did not file a Section 1A application, which a lot of you are not going to do, and that's okay. But you do have to file a statement of use. All right. So if you filed a Section 1B application, if you filed an intent to use application, you're going to get what's called a notice of allowance. Okay. Now, with a Section 1B application, what that means is you're not done. Okay. You are not done. You do not yet have a registered mark. However, it's really good because you survived publication. The examiner has approved the application for registration. You just have to do one final thing. Okay. So after you get the notice of allowance under a Section 1B, you have 6 months to file a statement of use or an extension of time. Okay. So you have 6 months after the notice of allowance. Now, after that 6 months is up, if you do not file an extension of time or a statement of use, your trademark application will go abandoned. So remember, you're not done. It's really, really important for you to act. You have to file a statement of use or an extension of time. And you have 6 months from the notice of allowance date. Now, what does this mean? So this means that, let's say that you're selling clothing, that you're in the process of trying to protect your clothing brand, but you don't have all the shirts made, let's just say hypothetically, but you're in the situation where you got the notice of allowance. Okay, that's a really good situation because you can file a statement, extension of time, and it buys you 6 more months. Extensions of time cost $125 per class. So if you filed for your clothing brand under class 25 and you filed an extension of time, it would cost you $125, and then you'd get another 6 months. Okay, now here's the thing. You can take up to 5 extensions. So you essentially, and each extension buys you 6 months. So you basically have 3 years to file a statement of use, all right? But eventually you are going to have to file a statement of use in order to get your mark registered. So this is what I have shown here. So after you file your statement of use, it'll be accepted. If the statement of use is accepted, in other words, if the specimen satisfies all the requirements, then your mark will be registered. However, if your statement of use is denied for some reason, then you're going to get another office action and you'll have 6 months to respond to it. Basically, you'll have 6 more months to get your specimen cleared up and actually get your mark past the statement of use phase and registered. Okay. Now, as I've said, you can take up to 5 extensions, but eventually at the very end of this 3-year process, you're going to have to file a statement of use, right? And once you file your statement of use, it's then examined. And hopefully after that statement of use, your mark will be registered. All right. So this was a brief overview of the entire trademarking process. All right. Basically, to me, this is a really important graphic that we have right here because it shows you that both Section 1A and Section 1B applications go through the exact same filing process. It's just the very end where it's different. So after the publication period, if you filed an actual use application under Section 1A, your mark would be registered, right? That's what we're showing right here, registered, right? But if you didn't, then you still have to go about filing the notice of allowance, right? So, statement of use. So you're going to get the notice of allowance, and then you have to still take affirmative steps to submit a specimen showing actual use in commerce. All right. But again, this is the entire filing process. I hope you guys found this super helpful. I just wanted to give you guys an overview because we've been filing a lot of trademark applications, but I haven't been creating as much content around what happens after you file. So hopefully you guys find this super, super useful. It's really important. Get in as early a filing date as possible. And again, just remember, actual use applications and intent to use applications are going to go through the same filing process up until the very end after publication. And then the actual use applications, you're done, got your registered mark, all set to go. But intent to use applications still require you to file a statement of use. And again, you've got 6 months. You can take up to 5 extensions. Each extension is going to be $125 per class. And then at the end, you're eventually going to have to submit a statement of use. And if it's accepted, then your mark will be registered. If it's denied, then you'll have an office action, and you'll have to get the specimen up to snuff so that you can get your mark actually registered. And remember, statements of use cost presently $100 per class.